were expressly told not to import extraneous facts. And on that basis, we were given the name of the respondent, Wilson. We're given the name of the appellant, Wilson, name of the respondent, Rachel, bracketed CV. We're not told who Wilson specifically refers to, but we understand that we are presented with a fact sheet and we have to work within the ambit of what the facts provide. Also, Your Lordship, bracketed TV was simply stated to be a popular national television. What they do as it relates to whether human rights or not, we are not stated and we're not given. But we, from logical inference, assume that there are certain standards that obtain to a broadcasting station that has been tagged to be a popular national television. On that basis, Your Lordship, I would like to go ahead and respond to the fact or the issue or the arguments they raised as to the fact that Wilson is not a party or he was not being referred to in this instance case. Your Lordship, when we're presented with a fact and we are told who Wilson is and the things he suffered as a result of the defamatory allegations that were leveled against him, we will not go outside. We will not go outside and look for another Wilson who could have possibly been the person that was being referred to. Your Lordship, I would like to quickly mention the case of Dapialong versus Lalong, where types of parties were stated. There are proper parties, desirable parties, and necessary parties, but I would like to emphasize on desirable parties. These are parties who have interest and have been affected by the consequences of the respondents. Wilson, by virtue, if we're tallying with the argument that Wilson is not a party in this case, we would allege that Wilson is a desirable party because he has an interest that has been affected. He has losses that he has suffered as a result of these defamatory allegations that were made against him. Also, Your Lordship, I would also like to mention that, please permit me to transfer the proceedings to the third counsel to vote.
You made mention that the allegations were not
To the third party.
Your Lordship, a rebuttal of facts stated by the respondent counsel. In the facts given to us, the respondent, a popular television station, used the jingles produced by the appellant for commercial advertisement. If I'm right, the counsel said they didn't use it for commercial gain. My Lordship, it is logical to think that a television station like Broadcasting TV is highly popular in Abuja. Will not go for something of low quality to maintain the status quo of their company, of their television station, to maintain the status quo of their television station. They would rather go for something that will keep viewers glued to the TV. My Lord, I would like to refer you to the case of Hubbard versus Oscar, where your learned senior, Lord Jenny, Master of Roads, permit me, my Lord, to read verbatim. No fair dealing with a literary, dramatic, or musical shall constitute an infringement of the copyright in the work if it is for purposes of criticism or review, whether of that work or of another work, and it is accompanied by sufficient acknowledgements. Your Lordship, in the fact stated, they used it for commercial advertisements and not for criticism or review. Thank you.
Text or continue.
Okay. My Lord, after what the appellant has stated, I just want to say that the name listed, we're not contesting the fact that the first appellant has called. That's not the issue. The issue here that we have been raising is that appellant's argument, they did not sufficiently prove that Rachel made this statement particularly to Wilson. How then can we now say it's the Wilson? There are so many Wilsons. Also, my lords,
Sure.
Also, my lord, the council mentioned that there were extraneous facts that have been brought on board, and council is confused as to what she means by the extraneous facts, because we worked strictly on the statement of the agreed facts that were provided for us by this organization. But then we want to state that on issue one, which council
Forgetting what she said.
she introduced an extraneous fact by stating that repetitivity, in fact, she introduced repetitivity to issue one. And this is one thing we need to note, that when issues have already been differentiated, the first issue was supposed to target whether Rachel was liable in defamation, and then the second issue was supposed to talk about repetitivity. But bringing it into the issue one, that means that there was an extraneous fact on their end. Because of this, my lord, we just want to punish the court with the provisions of edging Wumi in the registered trustees of AMORC versus Awoni, when they stated that it must be borne in mind the second principle that the hearing and determination of any cause or matter must be confined to the course of action. The course of action that is supposed to be discussed in issue one is defamation of the first appellant by Rachel, not that Brekete TV published the statement. My lord, I will be handing over to my counsel to complete.
My lords, during the appellant counsel argument, they made mention to a jingle before they were cut short, being a literary work. My lords, thankfully, they gave us the definition of what a literary work is, mentioning writings, poetry, novels, and so many others. My lord, I'm struggling to find where exactly how a jingle fits into a literary work. My lords, how I'm confused as to how a jingle can qualify as a literary work. My lord, beyond that, they also erased the issue. They were contending the fact, you brought in extraneous facts about Brekete TV and complaining, they mentioned that Brekete TV, the facts only stated that Brekete TV is a television station. My lords, we reached out to the organizers of this competition when we read the facts, and we told them that the facts of this case are quite vague. And they told us that it was left vague intentionally so that parties can build upon it. My lord, how is giving a background to what? Yes, the fact states that Brekete TV is a television station. Fine. But it doesn't state that that is the only thing that Brekete TV does. And furthermore, we even stated that they talk about political issues. So we are not we are not contending the fact that Brekete TV is in fact a television station. However, we are saying that beyond being a television station, they are also a human rights organizations. So, my lord, I don't understand how this is an extraneous fact. My lord, we would like to conclude with the words of the revered Okuda GSC of blessed memory. My lord, justice is not a one-way traffic. Neither is justice a two-way traffic, but a three-way traffic. Justice for the plaintiff, justice for the defendant, and justice for the society. My lord, justice would only be served in this case when there is a dismissal of this suit. My lord, my clients are not Oliver Twist. All they are asking for is a dismissal of this suit. We would like this court to weigh all the facts and arguments canvassed by counsels.
Thank you, counsel. So we'll proceed and ask a few questions before we go in for recess and come out with the judgment as it may be. So first, the appellants, you mentioned you mentioned something about the jingle that it had to be written down inside a manuscript, I believe. Must it be written down first before such a sound can have copyright protection?
Well, copyright is something in work. It must be original and it must be in intangible medium. Your lordship, it's logical to know that for an artist, if he receives an inspiration from a song, he writes it down. The manuscript is the rough original work written down of that contains writing of the lyrics of the song.
You haven't answered my question. Must it be written down to afford it protection under copyright?
Contain a tangible form.
Must it be written?
No,
It mustn't. So if I record the jingle straight up, I don't write it down, I just go and create it. Is it protected in that medium?
the lordship, I provided for musical work.
Respondents Council, you mentioned that the Jingle Bells protection probably was used in a transformative medium, if I got you right. Are you saying that the copyright period has not elapsed?
No, my lord, we are saying that jingle bells as the jingle. Are you referring to the jingles of the second appellant? Oh, oh, my lord. We were basically stating that the song Jingle Bells has actually outlived its protection. Well, according to Nigeria's, the period for protection in Nigeria is 7 years. Well, it varies from countries. It varies rather from countries to countries. But yes, it has actually outlived its protection. But we are not basing our argument on the Jingle Bells.
I understand. I'm just testing your understanding. Now, they claim that the jingle in the instant case, you claim that it wasn't used for commercial purposes, but they claim that it was used for commercial purposes. How do you respond to that?
My lords, it was not used. I know that okay. The fact they mentioned commercial adverts. I don't know, maybe my friends in argument are mixing up commercial, the fact that commercial was mentioned in the fact of the case. Because a commercial advert does not mean that the advert was for a profit or was going to earn economic interest. So the jingles was actually used for a non-profit purpose because the program which it was used for was for a non-profit purpose, and this jingles was used in for the program.
Appellant, is that correct?
No, no, your lordship. If I clearly heard your lordship, said jingle bell. Your
No,
lordship,
jingle now in this case, the jingle that was used.
your lordship, I would like to give an example. Said commercial is there do not mean of financial value. I would like to give an example, your lordship.
All right, as far as it goes straight to the question I asked.
It is logical to think that for any advertisement you see on a TV station, it was paid for. So like, your lordship, I see no clear reason why the respondents would say it was of no, it was not for commercial gain. I hope
You want to ask questions?
So just to align that question, what does commercial
Well, I think the word commercial depends on the context in which it is used. If we are referring to commercial, in respect of let's say okay Commercial, if we say something was used for a commercial purpose, usually means for a purpose which would earn 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 profit. Yes. But if we say a commercial advert is basically advert that takes place. My lord, I actually went through my dictionary and checked for the meaning of a commercial advert. And a commercial advert is basically an advert that normal when something is being aired and in the midst of it, yes, in the midst of it, there's like a commercial break. Thank you. There's a commercial break and an advert is being aired. That was context. Yes, in the context, in this context.
Okay, that will all for now.
All right, so I'm going to be asking two questions to both counsel. So I'll throw the question and then you take something and I'll throw it. The first question is there a reason why you decided not to wear the collar?
Who doesn't have?
Ordinarily, you're not supposed to see, you're not supposed to grant the audience because you decided to roll, it means you have to be fully rolled. So is there a reason why you decided to, is it too disturbing?
My lord, actually, this is what our school provided. Okay, yes. Well, actually, we did not plan to row, but the AC was actually too much for us. I apologize.
And lastly, you made mention to Omura, and we were seeing Court of Appeal here. No, we were seeing yeah, Court of Appeal, and then you were mentioning Supreme Court. So I'm really confused.
My lord, please, can you direct us to the page of memory? Ah, my lord, it's an oversight on our part. We apologize. It's the Supreme Court.
So lastly, I also need to know why you don't structure your argument in paragraphs. Because while you were trying to refer to the statement of fact, you were like, oh, paragraph 4 of the statement of fact. So it was easy for us to go and check paragraph 4, and it was easy for you as well to refer to it. So, I mean, you have very beautiful grades, but is there a reason why you have failed to number paragraphs? But then, when you're preparing the grades, ensure to number it and reference it properly so that God should be properly read. And giving you admiration you can. I love our paragraph. This says this. Well done.
Thank you. And thank you to my colleagues in equity for referring to me. I don't know whether I'm the Supreme Court or Court of Appeal. Now, one of the Supreme Court, I hate your brother. Someone who said your senior. So I think we'll go for recess and then we'll come back and announce the results. So we shall run.
Hey, but that was Good. Bye. Oh, oh, thank you. Mary. Yeah.
See, you don't see, so we used to get to my love.